It's Michael Popok with the Legal AF Hot Take. If people think Donald Trump is going to testify on his own behalf in the New York criminal trial for election interference that's pending right now before Judge Merchan, where they're trying to pick a jury, well, he might. He might waive his Fifth Amendment privilege. He likes talking. He likes thinking he's the smartest person in the room. He might think he might be able to hold the rapt attention of the jury, a jury that he has a lot of disdain for, refuses to honor or respect during the selection process. But Donald Trump better think again, because the New York prosecutors, the Manhattan DA, have put him on notice by way of a filing we in New York call the Sandoval notice, based on a case's name, and told him about the 6 or 8 different things that he's done wrong in the past in a courtroom where he's been adjudged to be a fraudster, a persistent fraudster, somebody who's lied under oath, somebody who's been sanctioned and fined, somebody who's been fined for filing meritless bad faith cases, somebody who's been sanctioned over and over again. All that's coming in front of the jury in order not to prove that he did the crimes that are alleged, the Stormy Daniels election interference case, but to undermine his credibility. That's the right purpose of a Sandoval type evidence coming in. It's to provide notice to the defense of the misconduct and uncharged criminal acts that the people intend to use at trial as substantive proof. They have to tell them in advance, which they've done in the new filing. We'll put it up here. Now, let me explain what I'm talking about. In every state, whether it's called a Sandoval notice or not, the prosecution has a requirement that it let the defense know in advance if it's going to be using information about uncharged crimes and other bad acts against a defendant who takes the stand. So this is only applicable. This information I'm about to outline for you on this hot take would only come in the circumstance of Donald Trump taking the stand. Now, if Donald Trump does what I think he's going to do, which is to threaten to take the stand, brag that he's going to take the stand, tell his supporters that he'd love to take the stand, but at the last minute not take the stand because it's not going to help matters, it'll only make it worse. Donald Trump has a long history of making things worse in court for himself. I've never seen a litigant, even at his level, that has a knack for making things worse in court. I mean, I've represented clients where they didn't win the case for me, but they didn't lose the case for me. It was sort of a push. But for Donald Trump, it is inevitable that if he actually testifies or tries to do a closing argument or whatever, the jury will punish him because they don't like him, they don't believe him, they don't find him to be authentic or credible. Juries can smell a fraud, juries can smell inauthenticity, and juries know when they're being snowed a mile away. I've been in front of dozens of juries. I've helped select dozens more. I know how juries think, especially ones in Manhattan. So let me now give you the lineup. This is talk about headwinds, talk about turbulence that Donald Trump will walk into like a buzzsaw if he decides to take the stand. Let's say I'm wrong. It's happened before. Say I'm wrong, and Donald Trump's lawyers, or over their objection, Donald Trump says, I need to take the stand. I need to be heard in a court of law about my criminal matters, despite the fact that the judge ultimately in sentencing and the jury in fact-finding has his his brass ones by in the palm of their hands. All right? Donald Trump could do it. But here is what the Manhattan prosecutors have told Donald Trump and the public in this filing that they're going to bring up. Let's start from the beginning. On page 1, they're telling Trump that, and this is another example of Donald Trump's other cases, his other conduct, his misconduct, wrongful conduct, accumulating and being used in other cases. I've said this before. The Manhattan DA is no dummies. They're the elite of the elite. They're the best of the best in the world in prosecutors. They sent people to go watch the E. Jean Carroll case for rape and defamation. and to see how Donald Trump would act in that courtroom. They sent people to the New York Attorney General, Letitia James's civil fraud case against Donald Trump, to watch that 12 weeks of trial and see how Donald Trump would act, because they wanted to learn from it. They wanted to gain a learning curve to help them in this case. And now they've got most of these cases listed, some of which you may have forgotten about, and I'll refresh your memory about Donald Trump's uncharged crimes and misconduct. Ever tried to break a bad habit and felt like you're climbing Mount Everest in flip-flops? Yeah, we've been there too. But here's a breath of fresh air. Fume. It's not about giving up. It's about switching up. Fume takes your bad habit and simply makes it better, healthier, and a whole lot more enjoyable. Fume is an innovative, award-winning flavored air device that does just that. Instead of vapor, Fume uses flavored air. Instead of electronics, Fume is completely natural. And instead of harmful chemicals, Fume uses delicious flavors. You get it. Instead of bad, Fume is good. It's a habit you're free to enjoy and makes replacing your bad habit easy. Your Fume comes with an adjustable airflow dial and is designed with movable parts and magnets for fidgeting, giving your fingers a lot to do, which is helpful for de-stressing and anxiety while breaking your habit. The first time I tried Fume, it was way more flavorful than I thought, and it feels very fresh. The look and feel of a Fume is very sleek. It's well weighted, perfectly balanced, and extremely fun to fidget with. Plus, Fume's just released a magnetic stand for your Fume, so there's no more losing it around the house. And it's built with fidgeting in mind. You can spin your Fume around on it. Start the year off right with the good habit by going to tryfume.com/legalaf and getting the Journey Pack today. Fume is giving listeners of the show 10% off when they use my code LegalAF to help make starting the good habit that much easier. Start the good habit at tryfume.com/legalaf to save 10% off the Journey Pack today. First, they say they're going to cross-examine Donald Trump and tell the jury about what happened in Letitia James's case against Donald Trump under Executive Law 63-12 for fraud, in which she obtained a $354 million in change judgment. That there was evidence, and it was proven in a court of law in front of Judge Engoron, that Donald Trump committed repeated and persistent fraud, false business records, false financial statements, conspiracy to commit insurance fraud. Jurors love fraud. It's the number one way you can undermine somebody's credibility when they're testifying, is to tell the jury that they have been adjudged to have committed various types of fraud. In other words, they can't be trusted and their word can't be trusted. So that's coming in, or that's what the government contends they should be able to cross-examine Donald Trump on. They also, while we're in that case of people by James versus Trump, which means people by the Attorney General, Letitia James, they also want to tell the jury Donald Trump, cross-examine him on his untruthful statements under oath. Judge Engoron found that Donald Trump lied under oath about him not meaning to attack the principal law clerk for Judge Engoron, a woman that Donald Trump mercilessly doxed and attacked time and time again, and then lied about it under oath in front of the judge. Judge found that he lied and fined him $10,000. They also want to tell the jury in cross-examination of Donald Trump about other fines that the judge hit Donald Trump with for violations of his gag order, and that he frequently lied about his finances. Then they want to move on to the two E. Jean Carroll cases, both successful for E. Jean Carroll. One proving rape or at least sexual assault in New York, plus punitive damages in the first case, punitive damages and continued defamation in the second case. They want to tell the jury that Donald Trump was on the receiving end of an $83 million punitive damage award in the first case. And also that in the second case, the E. Jean Carroll 2, he got hit with another sum of money, and that the judge also sanctioned him in that case related to his public statements. Then they want to move down and tell as long as they're at it and they're cross-examining Donald Trump, the Manhattan prosecutors want to be able to tell the jury about Trump versus Clinton, which was brought by Alina Habba for Donald Trump, in which Judge Middlebrooks down in Miami sanctioned Donald Trump and ordered him to pay almost $1 million for filing a frivolous and bad faith suit. And they quote the court down there as follows, which they want to bring out in front of the jury here in New York. Quote from Judge Middlebrooks, "Here we're confronted with a lawsuit that should never have been filed by Donald Trump and was completely frivolous, both factually and legally, and which was brought in bad faith for an improper purpose." Judge went on. Judge Middlebrooks continued, "Mr. Trump is a prolific and sophisticated litigant who is repeatedly using the courts to seek revenge on political adversaries. He is the mastermind of strategic abuse of the judicial process, and he cannot be seen as a litigant blindly following the advice of a lawyer. He knew well the impact of his actions." Then we want to talk. Then the Manhattan DA wants to tell the jury, as long as Donald Trump's up on the stand trying to defend himself, about People versus the Trump Corporation, a case from 2022 in which this Manhattan DA's office was successful in prosecuting at least two of Donald Trump's company, including Trump Corporation and Trump Payroll Corporation, and convicted them of schemes to defraud and conspiracies to commit criminal tax fraud, and just like this case, falsifying business records. And obtained a 17-count conviction against those companies for fraud. And then they want to tell the jury about a 2019 case that most of us may have forgotten, which was People by James again, Letitia James against Donald Trump back in 2019, that he illegally allowed his 2016 presidential campaign, just like what's at issue in the current criminal case in New York, to orchestrate a fundraiser for the Donald J. Trump Foundation. In other words, they took illicit, improper donations for a foundation through his presidential campaign, and he was ordered to pay $2 million for that set of illegal campaign issues. That goes right to the heart of the matter in the Manhattan DA's case right now, because you've got the 2016 presidential election and you got improper election interference and campaign violations. So, of course, that's going to be interesting to the jury. And then there's another case from 2018 that they want to mention, which is a stipulation to dissolve his foundation. In that case, we just talked about the People versus Trump case, to dissolve that foundation to resolve the claim. So he had to pay $2 million and he had to dissolve his company, and also which resolved this fiduciary duty breach and fraud claims. So what we have with the Sandoval notice is that Donald Trump, if he takes the stand, is going to have to put on a hard hat, because there's going to be a lot of incoming missiles that are going to try to take him out as a credible witness when the Manhattan DA is done reciting all of these bad deeds, bad acts, and uncharged crimes that Donald Trump's going to have to answer for in front of the jury. Now, Judge Merchan's still going to have to decide which, if any, of these items are going to be able to come in, but it becomes fair game if Donald Trump takes the stand. Now, he doesn't have to. Our system of justice, of course, you're presumed innocent until proven guilty, and you have a Fifth Amendment right against self-incrimination. And just to balance the scales of justice and make it harder, the burden is on the prosecutor to prove beyond a reasonable, not all, a reasonable doubt. So that's how that works. So the judge is going to look at that list. My gut is he's going to let in the campaign violations and the fines that he received and the dissolution of his foundation by Letitia James. He's going to let in the persistent fraud findings against him. He's going to let in that his companies were convicted of crimes in the past, although that one's a close call, because that one, there's a balancing scale the judge has to do. He has to look at whether the probative value, which is whether it tends to prove a fact in the matter, is outweighed by the prejudicial impact. This 401, 403 balancing under the rules of evidence, or the equivalency in New York, is something that's constantly done by the courts to try to determine. Everything on that list is obviously probative. Everything is relevant. The jury would love to know it. The question for the judge is, will it blow their minds and will the prejudice that will be heaped on Donald Trump be so great that there's a fear that they're convicting not because of what he's being charged with now, the election interference / business record fraud, but that they're convicting him because he's a bad guy. It's a bad guy conviction. You can't have a bad guy conviction in our court system. And so that's what the judge is going to balance. But I think a lot of what I just laid out comes in. There'll be a hearing about it, but I like the robust filing by the prosecutors. And I like that all the bad things that have happened to Donald Trump out of his own making the last 4 years are coming home to roost here. They could have, but didn't list. He's been indicted in other places, right? That would have been, I think, beyond the pale. You can't, just because the guy's criminally indicted other places, that would definitely blow the jury's mind. I mean, they know it already. But to hear he's been indicted, 91 felony counts, including in Georgia, D.C. election interference, Mar-a-Lago, special counsel. I mean, it's like too much. I mean, at that point, they might as well just strap him into the chair. So the judge has to worry about that. But a lot of what I just read out loud in the Sandoval notice is going to come in if, but make it clear, Donald Trump takes the stand. If he doesn't take the stand, none of this can come in. The jury is not, this goes to credibility of somebody who's actually testifying. And so I want to make that clear. We'll continue to follow what happens with the Sandoval notice, the hearing over it, what the judge allows in, whether that's a setback for Donald Trump or not. But I assure you, a good, healthy proportion of this, a lion's share of this is coming in front of that jury. And then I can talk to you from a trial lawyer perspective about the impact of it. I'll follow it in one place. You know where. You're right here. MeidasTouch Network. Free subscribe. Get them to 3 million free subscribers before the 5th of November. Then join us every Wednesday and Saturday on Legal AF, our podcast at the intersection of law and politics. It means exactly what you think, or if you don't know, join us and you'll find out why we call it Legal AF. And then I do hot takes about every day, if not every hour, right here on the MeidasTouch Network. So until my next hot take, until my next Legal AF, until my next patreon.com/legalaf exclusive content. This is Michael Popok reporting. Heary, heary, Legal AF Law Breakdown is now in session. Go beyond the headlines and get a deep dive into the important legal concepts you need to know and we discuss every day on Legal AF. Exclusive content you won't find anywhere else, all for the price of a couple of cups of coffee. Join us at patreon.com/legalaf. That's patreon.com/legalaf.